So today I'll be talking about my final project and the court cases that I've decided to choose. So let's get started. So first I'll be talking about my career aspirations. Then following that, key terms, the cases I decided to choose. I decided to choose three cases on hiring discrimination, gender discrimination, and sexual harassment. Um, then I will talk about the importance of each case and the value of the cases, and then I will finally conclude. So for some of my career aspirations, like I stated in my introductory video, I want to go into human resource management. I talked about wanting to work abroad or internationally. That is still a goal for me. Now it's either deciding on what to work, corporate or nonprofit, working towards my master's degree, and then working alongside of onboarding, retention, employee relation, and training development. So some of the key terms that I'm just going to debrief you guys on is sexual harassment in the workplace is basically a coworker propositions you for sexual favors repeatedly supervisors who make frequent or lewd jokes to male employees. The most common is pro quo harassment. Supervisors propositions a subordinate for sexual favors in exchange for a promotion, salary raise, job shiftment. And then the next term is retention or retaliation, includes taking an advised employment against an employee who has asserted his or her right to against discrimination. It also is unlawful for an employee to retaliate against a victim of sexual harassment. The next key term is hiring discrimination. Is an employee cannot post a job advertisement that shows a preference for hiring on the basis of race, color, national origin, sex, or disability. And then gender/sex discrimination is based on discrimination against someone because of a transgender identity. And then so there's like two forms of gender and sex discrimination. Is disparate treatment is in context of sex discrimination is any unfavorable treatment that is motivated by an employee's sex or gender identity. And then the next one is disparate impact, the look or neutral on their face, wind up upon effects on people in particular groups, even though employees denies he or she intended to do so. So those terms are going to come up throughout the case studies that I reviewed and chose for today's topic. Another big one is Title VII. Title VII of the Civil Rights Acts of 1964. It's the federal law that protects employees against discrimination based on race, color, national origin, sex, religion. An employee may not discriminate with regards to any of the terms and conditions of the privileged employment. Title VII applies to both private and public sectors. No employee can be treated differently based on his or her association with someone who has one of these protected characteristics. Additionally, no employment decisions may be made on the basis of stereotypes, assumptions related to protective characteristics. So those are some of the main factors in the cases that I decided to choose today to talk to you guys about. So my first case is Equal Employment Opportunity Commission versus Abercrombie and Fitch stores. Throughout the presentation, I will just now say EEOC instead of the Equal Employment Opportunity Commission because it's long. So this case is about hiring discrimination. In 2008, Abercrombie and Fitch refused to hire Samantha Elfrod, who is a Muslim, because of her religious practice of wearing a hijab. At the time, it did not fit Abercrombie and Fitch's look policy, which Abercrombie claimed it banned all hair covers or hats and coverings. She applied for the position in the store and was interviewed by Heather Cook, at the store's assistant manager. Cook used all of Abercrombie's normal hiring evaluation systems, and she rated Alfred qualified to be hired, but was concerned, however, of her hijab, so um, that it would like conflict with this store's look policy. So she went to her hire manager and um, asked for guidance and clarification regarding the hijab and the whole look policy. Um, the district manager then um, informed Cook that the headscarf would be in violation of their look policy. So he told her not to hire her. Um, yeah, and then after this, she filed a charge with the EEOC alleging religious discrimination. The EEOC filed a suit against Abercrombie and Fitch, charging the company to refuse hire due to her religion, and it failed to accommodate her religious beliefs by making an exemption to its look policy for prohibiting head coverings. So, so this case actually went all the way to the Supreme Court. The district court granted summary judgment on liability to the EEOC, and then granting that the evidence established that Alfred wore the hijab as part of her Muslim faith. Then on July 27, 2015, the 10th Circuit revised, awarding Abercrombie and Fitch the summary of judgment on the grounds that the failure to accommodate liability religious practice until the applicant or employee provides the employee with actual knowledge of the accommodation. And then the Supreme Court overruled that and then said that employer may not refuse to hire applicant if employee was motivated by avoiding the need to accommodate the religious practice. This behavior violates the Civil Rights Act and the Title VII. So the decision following this was the Supreme Court ruled against the retailer Abercrombie and Fitch 8-1, deciding that the company's failure to accommodate the job applications who wore the hijab. And then the Supreme Court also held that the employee may not refuse to hire applicant if the employer was motivated by avoiding the need to accommodate religious practice. So for my next case, it's going to be about Macy versus Holder. Again, with the EEOC and hiring on gender discrimination. So a lot of background information, but basically Macy is a transgender woman who in 2010 decided to move back to her home state in San Francisco due to family reasons. At the current time, she was living in Phoenix, Arizona, and her supervisor in Phoenix told her about a job open position at Walnut Creek Crime Laboratory. So Macy was a police officer too, so she had many qualifications. She's also trained and certified as an NIBIN operator. Following that, Macy had a phone interview with the director of Walnut Creek Crime Laboratory, and in that phone conversation, they talked about salary, job descriptions, qualifications. The director told her that she'd be able to have the position, assuming everything went well with her background check. And then in January of 2011, Macy followed up asking the status on her application, and the director told her the job was pending on the completion of her background check. And then in March 29th, 2011, Macy emailed the Walnut Creek Laboratory that she is transitioning from male to female, and that requested information to be sent to the director. And then on April 3rd, she confirmed that her name had been changed and everything. And then as of April 8th, Macy received an email from the director of operations saying to federal budget the position was no longer available. She was kind of concerned. She was concerned by this, so she on May 10th she contacted the agency EEOC and discussed her concerns. She also called and asked Wall Creek had not cut the position, but rather they took another applicant who was farther along in the process of the background check. So it was a little suspicious. So she filed a complaint with them because based on she believed that it was her informing them that she was transitioning from male to female, and so that is gender discrimination even higher. So then the decision ruling in the case was that in April 20th, 2012, holding the Title VII prohibited against sex discrimination include discrimination against transgender employees. And then the EOC directed ATF applied it to Mia's complaint. The commission ruled in Mia Macy's complaint that the anti-transgender discrimination is a type of sex discrimination and therefore illegal under Title VII and the Civil Rights Act. That's another case I talked about. And then moving on to my third and final case is EOC versus Chipotle Mexican Grill. This case is about an employee named Austin Melton who transferred from North Capitol Avenue restaurant in San Jose to a different location in California. It was his first real-time job, and in this job, his general manager began subjecting him to unwelcome sexual comments, propositions, and physical touching. As in April 2015, and then Melton filed a harassment based on his sex, which was male, because which was created an abusive, intimidating, hostile work environment, include both verbal and physical. He had to force so much from his manager and physical harassment. Now, going on through this portion of this court case, I will refer to the general manager as just the GM, and then team leader as TL for reference. So some of the first claim was sexual harassment. The GM repeatedly slapped, groped Melton's buttocks, groin area numerous times. The GM also made sexual comments such as, "I'll pay for sex. I want to watch you and your girlfriend have sex. I want to do a threesome with you and your girlfriend, and you're hot." This continued to go on. Melton, and she wouldn't just do this to Melton, she actually did this to all the employees who were working the same shifts. She was just very inappropriate. Melton and coworker complained to the team leader the first time in early September 2015, and the team leader told Melton that he would talk to the GM. However, the harassment continued, and then Melton complained verbally to the team leader for a second time in October 2015, and the team leader called the GM and Melton into a meeting, and then during the meeting, the GM became very hostile and started screaming at Melton, which is very unprofessional and very not normal for a manager to do, so that was an issue too. Then the second was retaliation. After the second complaint to the team leader, the GM had been verbally and physically harassing him. After the second complaint, managers and employees retaliated against Melton. The GM told other employees who were working the same shifts, don't talk to him, don't acknowledge him. They also locked him up in a closet, or not a closet, a freezer, and moved his motorcycle into a different parking lot. The only way he could escape was through the emergency exit. So this was creating a very hostile environment for Melton. And then, yes. And so this is the decision. I actually, while I was still researching this case, I wanted I couldn't find really anything, but the case is still going on June 10th, 2019. Judge Freeman, he ordered granting motion to extend the fact discovery cutoff or additional depositions by August 1st, 2019. So I'm really interested to see where this case will end up and how it will end. Obviously, this is a huge issue. I picked majority. This is something that's been happening more and more often, and companies need to be more responsible and with their training, and it's a bigger issue than most people think. Um, so the relevance of each case is why I chose. It's important me wanting to go into human resources is rather it is recruiting new employees, helping with training development to make sure I know and they know what like the rules and laws are regarding, so that I can help navigate and ensure there's no costly fines or other penalties, including the potential to harm the organization that I work for. So making sure I know what's right and what's wrong, and I don't discriminate or hurt, and that I don't discriminate against any future employee, or that I know the how to follow up and how to proceed with legal affairs with harassment cases. That is why I chose these cases. I think it's I will see a lot of these in my future, depending on where I end up, even though it's just good to know these basic rights. And then following that, here are my citations from all the 3 court cases that I've said. And yeah.